All right, the court is calling. Oh, you ready, Brenda? 2022 CR 6641.
This is not your average day in court. Welcome to Court Stream, where the stakes are real and the drama is raw. Today's case: one man, two women. A spiraling cycle of jealousy, denial, and obsession, all culminating in shattered windows, restraining orders, and emotional confrontations. At the center of it all, Christopher Joe Medina, charged with criminal mischief for a destructive outburst that started with a fire extinguisher and ended in felony territory. But here's the twist. This isn't just about property damage. It's about obsession that turned personal. A 5-year relationship, a child, a woman who says no more, and a man who couldn't let go. Judge Boyd is having none of it. Her gavel comes down hard, her words even harder. Stay locked in, because this hearing will expose not just the law, but the limits of love, the consequences of clinging, and what happens when you cross legal and emotional boundaries. Get ready for a full breakdown. This one gets real.
Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For the defense?
Ruben Pisania for the defense.
And are you Mr. Medina? Mr. Medina, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of criminal mischief, 2,500 to 30,000 as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
The charge here: criminal mischief between $2,500 and $30,000, is no joke. This isn't petty vandalism. It's a state jail felony, which means it carries real teeth, up to 2 years behind bars and a hefty fine. Here's the thing most people miss in Texas. Criminal mischief isn't just spray paint and broken glass. It includes any intentional damage to property. And in this case, Medina went full fire extinguisher assault on his ex's front door and smashed her car. That's thousands in damage, easy. And let's pause on this. Why a fire extinguisher? What was the end game there? Audience, drop your thoughts. Was this a cry for help or straight up intimidation? Would you consider that mischief or something more sinister? Judge Boyd immediately homes in on the psychological angle, but the legal foundation is solid: damage, motive, and consequences. And this court isn't playing.
Yes,
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, this punishment is to be assessed at 1 year in the state jail facility, $1,200 fine, probated, no application for deferred adjudication. The state recommends community supervision. There is restitution, if any, to Elmar, Elimar Morales. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 3 years. There'll be 100 hours community service restitution, no contact with Elimar Morales, and anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
No. Did you have Charles Blunt come back? State, any evidence to support the plea?
Judge, state offers State's Exhibit 1 in all attachments.
Any objection?
No objection.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
With the guilty plea locked in and no contest given, the court sails into sentencing. And here's the power shift. Judge Boyd is in complete control now. She doesn't have to follow the plea bargain. That's important. This is where things get tense. The courtroom feels it. Medina is silent, and you can see the gears turning in Judge Boyd's mind. This isn't just about restitution or jail time. It's about sending a message. And Judge Boyd, she's clearly done seeing women put in danger because someone couldn't accept it was over. Audience, real talk. Do you think plea bargains should be honored when emotions run this high? Or should judges have full power to override when danger is involved? This isn't just justice, it's a lesson in boundaries, and the warning signs many ignore until it's too late.
Yes, sir.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, do you want to tell me why you're knocking on the door of somebody who obviously does not want to be with you anymore? This is not a joke.
No, I'm not laughing.
So here's the thing. She doesn't want you. You came over to her apartment. You come over there with a fire. Don't give me attitude because I don't have to follow this agreement. You can't go to trial. So here's the question. She doesn't want you anymore. So why are you going over to her apartment, knocking on her front door with a fire extinguisher, spraying the front door with the fire extinguisher, and then breaking her car? Why are you doing that?
Let's break this down. The defendant shows up to an ex's apartment, uninvited, armed with, of all things, a fire extinguisher. He sprays it, then breaks her car. That's targeted, intentional destruction. Judge Boyd's tone shifts fast. This is not a petty dispute. She sees the danger. You can hear her voice harden as she drills the emotional core. She doesn't want you anymore. Now ask yourself, is this obsession, harassment, or both? And Medina's answer, I couldn't accept it. He admits it. That's chilling. Not only does he confirm the motive, but he also illustrates how delusion can spiral into criminal behavior. Let us know in the comments, do you think this moment should have led to jail time right then and there?
I understand what I did was wrong.
But why did you do it? Do you not understand when people don't want you anymore?
I couldn't accept it.
Why not? She doesn't want you. How old are you?
From I'm 23, yes, ma'am. From a recent situation that we've been in, me and my daughter's mom been together for 5 years. I've always tried leaving the woman. She never let me. And
No, people do let you leave. You say, I'm
she
gone,
never
bye.
did. She never did, ma'am. And when she wanted to leave, no, I didn't accept it. And I acted out 8 months ago. And well, she's coming back. She's messing with me and I have to.
No, you're not going to have any contact with her. And here's the thing.
I
This is what people need to understand. I don't know if people have this Romeo and Juliet complex that it appears that it's the end thing to do. But guess what? When people don't want you anymore, you leave them.
No, I completely
And
understand.
there's no thing as she won't let me leave. You know how you leave somebody? Bye.
Judge Boyd doesn't just hand down law, she delivers life lessons. That line, there is no such thing as she wouldn't let me leave. That's gold. She's demolishing a common excuse used by abusers, blaming the victim for staying. In one statement, she reframes accountability. And then, boom, she lays out a real solution. Get an attorney, file for custody, and walk away. This is one of the most powerful teaching moments of the entire hearing. She's not just talking to Medina, she's talking to every viewer who's ever thought staying in chaos was love. Would you call this tough love, or necessary law and order wisdom? Let us know.
If you have a child together, you get an attorney to apply for a custody agreement. That's how you leave somebody. And I'm telling you right now, you are not going to have any contact with her. If she comes and knocks on your door, you're going to have to call the police.
I do have a police report, ma'am.
Are you employed?
Yes, ma'am.
What do you do?
I'm a barber.
And how many children do you have?
One, ma'am.
All right, this is the court is going to do. The court is going to sentence you to 1 year in the state jail facility, suspended and probated for 3 years. There's a $1,200 fine that will be probated. There's to be no contact with Elamar Morales.
Here's where the legal precision comes in. The court now lays down no contact orders, and Medina's reaction, he tries to clarify which woman, because apparently there are two. So now we learn Morales is the car owner, but Brenda Martinez is the mother of his child. This adds emotional and legal complexity. Why is this crucial? Because it shows how tangled personal and legal obligations become in domestic cases, and the court must now track two victims, two relationships, and two boundaries. That's a logistical challenge for probation officers and a psychological trap for the defendant. Question for the viewers: should courts handle these overlapping relationships differently, or is Judge Boyd doing it right by separating the women legally?
Elmore is not my daughter's mom.
And yeah, Judge, I was.
What's the name of the mother?
I believe it's Brenda Martinez.
Yes.
All right, or Brenda Martinez. Is there any restitution?
That we were not aware of, Judge, to Brenda Martinez. We were just really given the information on.
Well, no, I mean, Elamar Morales.
Yes, on Elamar Morales, there was restitution. She's the owner of the car.
Okay, restitution, if any, to Elamar Morales. And if there's an issue with restitution, you can come back.
Yes, yes, Your Honor.
I'm expecting the restitution to be whatever the deductible was. However, of course, if she didn't go through her insurance company, then that will be something different. So there's restitution, if any, to Elamar Morales, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. If you're drug tested today, what are the results going to be?
Negative.
All right, we're going to do a drug test today. If he is negative, then we'll do regular UAs. There's to be regular reporting by Zoom or in person. Anger management. 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived.
This is more than sentencing. This is rehabilitation in motion, anger management, parenting classes, GPS monitoring, community service. It's a full package, not just punishment, but correction. And get this, 40 hours waived if he gets vaccinated. That's a smart incentive system being layered into justice. Whether you agree with it or not, it's a fascinating blend of public health and legal leverage. Judge Boyd is crafting a conditional pathway, but it only works if Medina follows through. Here's the dilemma. When someone admits they can't let go, can classes and check-ins really change their mindset? Or is this setting up for a repeat offense?
Parenting classes with Triple T. Once those parenting classes are completed, the remaining hours will be waived. I'm going to want field visits 3 times per month until further notice. Is there anything you need from the court in order to be successful? All right, we are off the record. Do you need any water?
Yes.
All right, just have a seat on the front row.
One quick thing. He did want me to let you know, he just had a drug test done on the 7th. I don't know if that's soon enough to be taken into consideration, but if you want one today, then that's fine.
All right, we'll do one today. All right, thank you. Hello, Mr. Medina. Every day every time I see you, there's a new color.
May I take off my jacket?
Well, sure, you can take it off, but you probably should do it out there, not in here. We're not doing a striptease,
No
you know?
problem.
Okay. All right, court is calling 2022 CR 6641, State of Texas versus Christopher Joe Medina. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Ruben Bisanya?
And are you Christopher Joe Medina? All right, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Christopher Joe Medina who was placed on community supervision in 2022 CR 6641 for the offense of criminal mischief, 2,500 to 30,000 on November 15, 2022 for a term of 3 years? Is that you?
Yes, ma'am.
All right, state.
You want to see? Violation of condition number 23 on or about the 12th day of March, 2023 in Bear County, Texas, the defendant Christopher Joe Medina did then in their contact or attempt to contact Brenda Martinez or a family member by telephone, mail, or in person in violation of condition number 23.
How do you plead to that? True or not true?
This is strike 2. After already being told no contact, Medina violates the condition and reaches out again. That's huge. The court now revisits the case under a motion to revoke supervision, and the judge doesn't hold back. She reaffirms the same boundary, no contact, period. But then something rare. She drops a metaphor, the orchid test. Get a plant. Care for it. If you can keep it alive, maybe you're ready for a relationship. Witty. Yes. Meaningful. Absolutely. It's about emotional maturity, and in courtroom context, it hits hard. Do you think metaphors like that stick with defendants more than legal jargon? Sound off in the comments.
State,
Your Honor, we'll waive the first violation.
any objections to the waivers?
No objection.
Did you understand by pleading true to violation of condition number 23, the court could find it true, grant the motion, sentence you to 1 year in the state jail facility and up to $1,200 fine? Did you understand that?
And there it is. The ultimate warning. Contact Brenda again, and Medina will face real jail time. 1 year. No more leniency. The energy shifts here. Judge Boyd isn't pleading. She's issuing final orders. This is about protecting victims, setting hard lines, and cutting emotional ties with cold legal authority. And Medina still looks like he's processing. Here's the question. Should courts always give this many chances? Or was leniency already pushed too far?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 23?
Yes, ma'am.
Court will find violation of condition number 23 true. Is there an agreement?
Your Honor, there is an agreed recommendation to deny this motion, however, to alter and amend his conditions to have 1 year of the GPS tracking and the curfew, which he is currently on as part of his bond.
All right, and what is this curfew?
Yeah, I'm sorry, may I speak?
Yes,
My work hours are 8 AM to 10 PM. I'm a barber.
So
10 p.m.
Yeah,
Barber.
I'm a late. I make late appointments. Yes, ma'am. I mean,
All right,
some-
you're gonna, if I do that, you're gonna have to provide proof that you're doing that. Okay,
Yeah. I do get home earlier sometimes. I mean, it's not always 10 PM, but 8, 9, but 10 PM.
all right, I'm just gonna put him on, I'll put him on partial GPS for work, and you're gonna have to provide your hours to probation, and you're gonna have to provide a list of, this is my client, this is my schedule. You understand?
I completely understand.
All right. And since he has the new number 1, I'm not gonna put him under oath, but Brenda Martinez,
My daughter's mom.
you can't have any contact with her.
I completely understand.
All right, if you contact her, you're gonna be looking at 1 year in the state jail facility here. I don't know what they're doing in misdemeanor court, because that's not my jurisdiction, but I'm telling you here, you cannot have contact with her. It appears to the court that she don't want you anymore. She don't want to be with you. And you know what? You got to accept that, move on. Maybe that, I'm a firm believer that sometimes everything happens for a reason. It's for the best. Maybe there's somebody else out there for you. But before you get in another relationship, this is what I always tell people. Get an orchid. My staff are always doing this thing where they buy me an orchid, right? And they give me the orchid. The orchid has beautiful flowers on it. You go out, get an orchid. I've seen them at Walmart and other places. They're probably like about $12. Save up $12, get an orchid. Flowers are bloom. Once those flowers fall off, if that orchid blooms again for you, then you probably are ready for a relationship. And I mean that in all seriousness, because I have received probably 3 or 4 orchids. They didn't make it. Because orchids, no matter the instructions you read, sometimes they like to be a little near a little light. Sometimes they don't like to be any light. Sometimes, they don't want to be touched. Sometimes they like a little water, not a lot of water. I don't know what the secret is, but that orchid will help you with patience and help you understand your feelings and get in touch with you. All right. So before you move on to another relationship, you need to work on you. You understand?
Yes, ma'am.
All right. So I'm going to deny the motion, alter and amend conditions to include partial GPS, for employment. Are the fees on the GPS waived or no?
Not on probation.
All right, I'll ask that the fees be waived. I'm gonna ask for. Oh, I already asked for you to do parenting classes. Have you done your parenting classes?
On the conditions, it says parenting program triple T instead of P.
No, triple P.
Triple
alright.
P. I was gonna take it yesterday, but I was confused with the T.
All right, so
I
I'm
can
gonna do
get it done tonight.
all right, well, it's gonna take longer than that,
Okay.
but all right, so I want him to start on his parenting classes. And that'll be triple P,
Triple
or
P.
either he can do compadre and compadre, either one. And there's to be no contact with Brenda Martinez. And the GPS is until further notice. Is there anything else you need from the court to be successful?
Oh, man.
How old are you?
I'm 23. I turned 24 in July, man.
All right, so get your life together. You have a child, right?
Yes, ma'am.
How old is your child?
She turns 3 in August.
All right. You know, time goes by quickly when children are that young. Just think, everything that you do, you need to ask yourself, is this something that could potentially result in me being away from my daughter for a year? The state jail felony time is supposed to be day for day. You understand? All right. Is there anything else you need? Probation, anything else he needs? All right, good luck to you.
Thank you so much.
You're welcome. All right, court is calling 2022 CR 6641, State of Texas versus Christopher Joe Medina. Can I have parties announced for the record for the state?
Second for the state.
Defense? Are you Mr. Medina?
Yes, Your Honor.
Going to show you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Christopher Joe Medina who was placed on community supervision in 2022 CR 6641 for the offense of criminal mischief, $2,500 to $30,000 on November 15, 2022 for a term of 3 years? Is that you?
Yes, Your Honor.
State.
Your Honor, violation of condition number 2. On or about the 20th day of October, 2023, in Bexar County, Texas, the defendant, Christopher Joe Medina, did then and there consume alcoholic beverages, namely alcohol, in violation of condition number 2.
How do you plead to that? True or not true?
True. True.
All right. Are you sure you want to plead true to that?
I think the confusion, Judge, I thought he was gonna read the diluted and not the alcohol, but it's fine.
All right. Are you pleading true to that?
True. And then, Your Honor, the state will waive and abandon the other violations.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you up to 1 year in the state jail facility?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
All right, your client seems as though he does not want to go forward with this.
I think he's just a nervous, Judge. He knows what the agreement is and he's satisfied with the agreement.
All right, did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, sentence you up to 1 year in the state jail facility?
Yes, ma'am.
So if you have an agreement with the state, court doesn't have to follow that agreement. Do you understand that?
I understand.
All right, the court will find violation of condition number 2 true. Is there a proposed agreement?
There is a proposed agreement.
And what is that?
It's essentially for revocation and adjudication via a judgment satisfied. And counsel and I spoke, and basically there's other violations that, again, we've already waived and abandoned, namely a couple of which that I think the state's gonna have some difficulty proving up at a future date and time. So just given the nature of what we proceeded on in terms of the violated condition, and given the potential, there may be some discussion on the actual days in, but given the potential great number of days in, we had a proposed agreement for, again, a judgment satisfied, Your Honor.
So what time are you all speaking about?
Well, Judge, we're asking for 30 days. I think the computer is incorrect. It shows 361 days credit, but I don't think that could possibly be correct because I know how much time he's actually spends in jail.
All right, did you all confer with probation over this?
Over how many days he had? No.
No, I mean, over what you all are proposing?
I had let Vashon know that we essentially, again, we're gonna have some difficulties with other things with respect to this defendant in the future. So given just a violation, we would be proceeding on the idea of revocation, adjudication, and a judgment satisfied.
The final outcome, 30 days in jail served, and the court rules the judgment satisfied. Let's break this down. Despite violations, emotional chaos, and back and forth compliance, Medina completed most of his probation requirements, anger management, parenting, outpatient treatment. So the judge weighs the progress and cuts a deal. But is this a win? That depends on whether Medina actually learns from this or sees it as a lucky break. If you were Judge Boyd, would you have honored this deal or gone tougher?
The probation standpoint is for revocation.
All right, so then the question is time. So I want to know what he's actually done on probation. Do we know?
In terms of his time, Judge,
No, I mean, what he's actually done on probation.
he's completed everything. Judge.
Well, we're gonna hear.
He completed outpatient treatment, Judge, in December of 2022. Anger management, parenting classes. Those are all of the classes that were mandated, so he's completed all of the classes. Community service hours is at a 0 balance. He has paid off his fees. And his latest UAs have all been negative.
All right, and when was his last UA?
Indicates on the court summary was February 20th of 2024.
All right. You give me a UA today, what's the result going to be?
Negative, Your Honor.
All right, let's do a UA.
Yes, ma'am.
Can I step up?
And yes, and then I'll make my decision. The court is back on the record in 2022 CR 6641, Christopher Medina. All right, probation tells me the results are negative. So I will follow your agreement. And is this 30 days in the Bear County Jail?
Yes, Judge, he did actually spend that pending the NGR before he posted his bond.
All right, court will sentence him under 1244 to 30 days in the Bear County Jail. Are you waiving your right to appeal?
Yes.
All right, and the court will give you credit for any time served, and the court will show that the judgment is satisfied. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, we can go off the record. Good luck to you. And I like the fact that I always tell the attorneys, mix it up a little bit with your clothing attire. So I do like.
And that concludes the roller coaster that is State of Texas v. Christopher Joe Medina. A case packed with heartbreak, legal maneuvers, and Judge Boyd's signature mix of discipline and wisdom. From fire extinguishers to flowers, from no contact violations to orchid metaphors, this courtroom gave us everything: tension, humanity, and justice. Medina's final sentence, 30 days served, judgment satisfied, but with clear warnings: one more slip, and the consequences get harsher. This wasn't just a legal case, it was a lesson in letting go, accepting rejection, and growing up fast. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.